Thank you all so much for joining us right here for After Hours. I am Christy Calcagno. We just had the first of possible many pre-trial hearings in the retrial of the Alex Murdaugh murder trial. I am right now joined by John Mobley, who is going to be kind of breaking down what we heard from this first pre-trial and basically what could possibly be happening, all until a tentative, right now, April 5th, 2027. Let me ask you, first off, at the bat, do we expect a trial date being set by the judge today?
Well, you know, Christy, I got to call it like I see it.
Yeah.
You know, I want to start by saying that, you know, Becky Hill's misconduct was just a gift to the defense. I mean, it's like manna from heaven for them to get the opportunity to try this case again, having learned from the mistakes the first time, which I hope they do. I am hoping that this time around we see a little less showboating and a little less posturing by the defense. I think there was a lot of that took place in the first trial, and I don't think it was particularly helpful to the defense. And I'm hoping that they take advantage of this rare second chance and do things slightly differently. So far, I'm not convinced they're going to do much differently. I'm looking at the pretrial motions they filed, and I have some thoughts on those. Mm-hmm. You know, one of the first things I want to address is the motion for the change of venue.
Yes.
I mean, one of the first thought that comes to my mind, you know, when you are telling the court that you're concerned about the pretrial publicity in this case, is that, okay, yet every time you turn around, the defense has their face in the cameras talking about the case on every local outfit, local media, national media. Every time you turn around, I mean, they haven't met a microphone and a camera they did not like yet, and they're doing that as much as they can, but they want to come to court now and say, hey, we're concerned about pretrial publicity. I kind of think that's disingenuous, first of all, okay? I think if you're concerned about pretrial publicity, you're not constantly talking to the press about the case, which they have done since the beginning. I want to be clear on that. Secondly, with regard to, you know, being concerned that they can't find jurors that aren't fair and impartial, that haven't heard about the case. You know, I don't think you can find jurors anywhere in the state of South Carolina, any county, that have not heard about this case, okay? I mean, what county is going to be different or better? Are you going to say Greenville or Richland County or Lexington County? You know, you're going to have jurors that haven't heard about the case? Well, of course not. Now, that just doesn't make any sense. And the standard is still the same. You know, if the jurors can be fair and impartial, then that's all the law requires when it comes to seating a jury. And I'm certain that they will find 12 people that will say, you know something, we've seen everything about this case, we've seen it in the news, we watched the numerous Netflix and made-for-TV movies, and we still believe we can make a decision based on the evidence in the case. And as long as you can find 12 people to say that, then that trial is staying exactly where it is, okay?
That was also something that we did not hear an actual decision on just yet from the judge. There was also a lot in this first pretrial that we did not get answers to. This is not the only one. We also talked about the technology, and we'll get to that in just a second, about with Murdaugh being able to have the laptop. We also talked about the outfit with the jumpsuit. A couple of answers that we did not get. We do know that the next pretrial is going to be August 14th, and then again a tentative possibly being on April 5th of 2027. So I wanted to kind of break down a little bit about what we heard today, and then also those pretrial motions which were brought up. First thing off the bat, though, the judge said, we're not really here about that. I have a couple of questions. So is that something, I know you have worked with McCaslin in the past. Is that how she runs her courtroom of, we have a tight ship, this is what we're going to do, and I want to get things on the board, like I want to get things on the calendar? Is that something that is pretty common for her to do? Yeah,
you know, matter of fact, the last murder I tried in front of Judge McCaslin. And I think it's important, and that she's doing it, she's establishing early on that she's in charge. Mm-hmm. I think with the lawyers in this case, you got to be careful because they will try to run a roughshod over you and try to, you know, take charge of the courtroom. So it's important that she kind of establish early on what the parameters are going to be. And I think it's also important that she's smart to make sure that she doesn't have any surprises. That if there's an issue that you want to address, you need to let me know now so I can start looking at it, preparing for it, as opposed to dropping these things on me at the last second. And now that's going to delay, you know, the trial because now I've got to research these issues or decide how I'm going to rule. You know, I would not be surprised if she makes a deadline for them to make all pretrial motions by a certain date. And that's probably what she's going to do. She did that in my trial, for example. She made it clear she wanted both the state and the defense to give her a list of all pretrial motions they plan to make by a certain deadline. And she is probably going to do that in this case, and that's a good way to really keep all the lawyers on a tight leash.
And kind of keeping everything on track when it comes to this too.
And no surprises.
No surprises. One thing that they did also bring up was the experts, and the experts being ready to go. The state saying that they are absolutely ready to go. However, the defense was saying we're going to need, and they were really pushing for a year or past a year. I wanted to get your reactions on in that. Do they need that year, saying that the defense needs more time, especially when it comes to getting the new evidence and using new technology?
I don't think they really need a year from that standpoint. They like the time, which, quite frankly, they shouldn't have to have a year. And I do want to address this new evidence request. I mean, and I want to be clear, they made a motion to have some genetic material tested, genetic material that was present during the first trial that they chose not to try to have tested. So now they're claiming that there's some new scientific process that was used in another case that was helpful to a defendant, and they want to try that in this case. Well, the thing about that is, in South Carolina or in any court, all scientific evidence is not automatically admissible. It's got to pass certain requirements regarding, reliability, accepted principles in the scientific community. Otherwise, it's just junk science, okay? So if this process is so new that it only came out since he's been convicted over the last couple of years, there's a real question in my mind as to whether or not this evidence or this procedure, this testing process would meet the requirements to be admissible in court in the state of South Carolina. And yes, it may have gotten admitted in another court in another state, but every state does not have the same requirements regarding admissibility. So I think they're kind of reaching on that. I think they're hopeful for something. I don't even know where they plan to go with it, because when you start doing independent testing of evidence, it can kind of go, it can be a double-edged sword. Because number one, you get that test result, it may not be the result that you want. and number two, even if it's not the result, even if it's not necessarily harmful, a lot of times the question is, well, what do you gain from it? Because a lot of times, it doesn't really prove anything. So you spent that money, you've put yourself out there like that, and ultimately it doesn't really prove anything. My thought on why they need more time is they want to see if they can get this stuff tested. They want to see what kind of results they get and have time to kind of pivot based on how it turns out. Because I cannot imagine that when you consider, all the evidence is the same, all the information is the same. This case has been under appeal. They've had plenty of time to give interviews all around the country. They have had time to find experts. In this case, they do not need another year to be ready.
For clarification, too, one thing that they're really talking about specifically was the DNA that was found underneath Maggie's fingernails there, and it was from an unknown man. So that was the example that they were using, the defense was using, where they're trying to use the same genealogy testing that was used in Houston, Texas for the Idaho murders with Mr. Koberger, saying that was able to help with that case. One thing that I was curious about is how, when that process does happen, SLED will then have to grant the permission to kind of give that DNA. So SLED, how does that kind of work when it comes to maybe this outside testing, and what does that process look like?
Well, SLED has very specific procedures for that. They're not going to just take genetic material in their custody and send it off to somebody in a different lab out of state. The chain of custody is very important. Documenting who was present, the procedures involved, and things like that. SLED is going to want that expert to come here and do the test under their supervision in all likelihood, and make sure they have their witnesses and experts present to make sure that if there are any issues or any kind of monkey business with the process or the procedure, that they have people that can, that are qualified to discuss, whether or not the process was accurate.
So, and also, it's funny you mentioned about the money too. One thing that the judge said, you're paying for it. And Griffin said, yes, that's right. We're going to be paying for that as well. That
is correct. And and again, if they have the money to do it, that's fine in this case. But again, there's a real question as to how much value that's going to add in this case.
Another big thing with value too, almost 20,000 pages with all of this documentation, all of this, and having Murdaugh being able to have access to this. One of the big topics of conversation, which we still didn't get an answer on, is the laptop. And if he's going to have access to this laptop, saying the state grand jury material is protected, attorneys have to look at it, defense says sure, but the state says no, he can't have a laptop inside his cell. The judge also talking to the warden saying no, he cannot have, for safety reasons, not have a laptop. How important is it for Murdaugh? And he does have a right to have access to this, but what does that kind of mean, and why is that such a huge argument on where he sees it and when he sees all of these 20,000 pages?
Well, I think that the big concern for the defense is if they have to sit with him to go over it, it just takes a lot of time. Well, I mean, that's just part of the deal. That's kind of what you sign up for. And they don't need to sit with him. They can have an assistant go, they can have a law clerk take the materials there and sit with him every day for the time he wants to read the materials. I mean, I can guarantee you the majority of the stuff he's seen already. I don't know, I mean, having been through one trial, I don't know what he's expecting to find or see differently than from the first time. I mean, he's been through this process. They discussed everything with him the first time. Now, if he wants to see it all again, sure. But again, I don't think it's necessary for him to have a laptop and have that privilege like he's in his office in private practice, again, reviewing discovery. He can have the discovery material, the police reports, the audio files, the witness statements, someone, a law clerk, a paralegal, an assistant, they can pay someone a very low hourly rate to take that stuff to him and sit there in jail with him every day while he reads it, and that'll be just as fine. That's
also a conversation that we still did not get a decision on from this pretrial, but that is something that we should be hearing a decision on, of course, before the trial date?
Yes, okay. I would agree.
Another thing that we still didn't get a decision on, but they did talk about, was what Murdaugh was going to be wearing. I know we talked about this too a little bit before we started chatting. Talk to me a little bit about that. When it comes to him being in the shackles, being in the jumpsuit versus him in street clothes, and kind of that argument from both the defense and the state.
I kind of think that's a joke. I want to clarify, the defense made a motion that Alex Murdaugh be allowed to wear street clothes, not shackles, in pretrial hearings. That's distinct and different from being dressed out during the trial. Every defendant during the actual trial itself is allowed to wear regular street clothes, a jacket and slacks, so the jury does not see the defendant in shackles. In pretrial hearings, there's no jury. But the defense is saying, well, because of the cameras, prospective jurors see him in shackles because, doing the pretrial hearings, and they don't want the jurors to see him in shackles because it might prejudice him at trial. I mean, I think that dog just does not hunt. I mean, anyone that's following this case, first of all, or that even if they're not following this case, knows that Alex Murdaugh is a convicted thief. He's admitted stealing money. He's admitted lying to the police in his own murder investigation. He's serving federal time for the federal crimes, so they know this man is a criminal, okay? And most people, rightfully so or not, believe he murdered his wife. But I mean, there's Netflix specials on the case, there's TV shows. I mean, there's so much coverage out there on this guy. Everyone knows he is a criminal, okay? So by putting him in a suit jacket for a pretrial status conference, prospective jurors are not going to look at him and go, oh, man, he looks good in that jacket. Maybe he didn't do it. I mean, that's just not going to fly. And the fact that they made the motion and then withdrew the motion kind of tells me they knew that really was not a legitimate motion to make.
There was a moment there in this hearing today where Dick Harpootlian had Murdaugh stand up and show everybody what he was wearing, also even pointing to the camera and saying that potential jurors are watching this right now and seeing him looking like that. Was that a interesting move on the state, or is that kind of going back to what we were talking about, what we possibly saw in the first trial?
That is, in my mind, consistent with what I described as that showboating and that posturing. Okay? That's great for the cameras. He gets that moment, gets in the spotlight, making this great argument, but at the end of the day, you withdrew the motion. So why make that argument when you withdrew the motion? Again, I think that's just showboating, and I don't think that's very useful for the defense in this case.
That's also something we still do not have a decision on yet, but again, we have many more pretrials to go. The judge also mentioned that. Here's what we did decide on. The pretrials are all going to stay in Lexington County. Thoughts on that? Does that really change anything?
Doesn't change anything at all. I mean, the judge can, in South Carolina, circuit court judges have jurisdiction pretty much anywhere.
Right.
She could have the pretrial hearings around her pool on a Friday afternoon if she wanted to. Okay. So I mean, she's got to make the decision. The law is going to be the same. There are no jurors involved in the process for pretrial motion, so it doesn't really make a difference where she holds those.
And that has really nothing to do, of course, where it's going to be over in April of next year, tentatively, because that has nothing to do with it, as we still haven't had a decision on where that's going to be.
Correct. And as far as April, I can guarantee the defense is going to make more motion to get that trial date postponed for numerous reasons. But I think it's good that she's making it clear that, hey, this is the trial date. Everyone needs to start getting ready. And although the defenses, I'm certain they're going to make motion to extend that trial date, I'm certain she is not going to do so unless there are extremely compelling reasons to do so.
Well, you already mentioned that too. What is something that we could possibly see in the next couple of pre-trials?
I think the biggest thing that really needs to be addressed is to what extent this judge is going to allow the state to introduce evidence of Murdaugh's financial crimes. Although the conviction was not reversed on those grounds, the Supreme Court did believe that, or did caution that it may have went on a little bit too much during the first trial. And I'm also thinking that the state may decide to kind of cut back on some of that, because I just think, following the first trial, I think that the evidence of financial crimes, it's long, it's voluminous, it's boring, and I think you lose the jury. You want them really focused on the murders and wanting someone to be held responsible or accountable for that. So, and honestly, if I'm the defense, I kind of let them put all that in. I just, I like to use something I call legal judo, and that's using the strength of the states against them. Because when I saw that first trial, the evidence of financial crimes was just so long and so monotonous and so boring. And then when it was time to present evidence to connect them to the murders, it was thin. And I would love to if I was defending this case, to stand in front of the jury and highlight that and say, listen, hey, you all heard about the money he stole. He admits that. The man's a thief. He stole money from clients. He stole from partners. He had a lot of evidence on that. And I said, okay, now let's talk about the evidence they had to connect him to the murder and contrast that. And I would argue to the jury that the reason they want you to focus on those financial crimes is they want you to hold that against them because they have so little evidence that ties them to the murder. Plus, I've always believed that another way that the defense could have used the evidence of the financial crimes was to argue that, you're right, he stole money from a lot of people. There are a lot of people upset with him. There are a lot of people that, that wanted to make him suffer. And that would give other individuals a motive to have committed the murders as opposed to him. So, I think that, handle the right way, let them get that financial evidence in. Let them do it all day long, because I think it really gives the defense a lot of information and ammunition to use to build a strong defense.
Jim Griffin did allude to it, but it really wasn't discussed in this pretrial.
No. I would kind of let it go.
Okay.
If I was defending this case, I would just sit there and let them put all that stuff in, not even ask. And unlike the first trial, I wouldn't even ask any questions. I was kind of surprised that during the first trial that they were actually cross-examining some of these witnesses, the defense was, and I'm thinking, why are you cross-examining these financial crime witnesses? He stole the money. He admitted stealing the money. You're wasting time. Let it go. Focus on the things that are significant.
Okay. And so as we are kind of hearing on into these next pre-trials, anything specific you think that we're going to really be focusing on August 14th?
Definitely the financial crimes.
Okay.
There's no doubt about that. They're going to push the change of venue, which again, I think as long as she tries to impanel a jury and the jurors say that they can be fair and impartial, but I know they're going to try to push that. I think that should be denied. But I think the big thing will be the financial crimes. I don't think we're going to see a whole lot new here. Mm-hmm. This case has been tried. That last trial was long. They had everything. The defense is not going to see anything different from the state. I think the big question I'm going to have is whether or not Murdaugh is going to testify this time, mm-hmm. which I don't think he should have done the first trial, quite frankly. But I don't think we're going to see too many surprises from the state. With the defense, the only thing for sure is nothing's for sure.
That is what we don't know, and that was straight from Harpootlian there earlier on in this pretrial. One thing that also was not mentioned, the death penalty.
Yeah, I don't think realistically that's on the table. I think for these, I mean, of course, the state has a right to do it. The facts of the case would qualify, but noticing the defendant for the death penalty in this case, that's going to, number one, push the trial date much further back because of the protections involved in death penalty cases. With the state must, bring in, psychologists and psychiatrists for examinations for the potential penalty phase. There's additional expenses for how they prosecute the cases and how they sequester jurors. And quite frankly, it's not a slam dunk case. I mean, while most people think he committed the crime, it's the evidence is not overwhelming. So the last thing you want to do is notice somebody in a murder for a death penalty and then risk getting the not guilty on a death penalty case. I think that the state's going to want to get this case sewn up fairly quickly. So I don't think death penalty is even a realistic option to be on the table in this case. I
also wanted to ask you to the new administration that we're going to be getting in November, of course, even before this trial date. Could that possibly change anything?
Possible.
Okay.
Likely, I would say not. I think the prosecutor of the first case, I mean, he's had it from the beginning. He knows the case inside and out. I thought that he was fairly consistent and steady with his prosecution. I don't think that the prosecution made any significant mistakes or any real mistakes, truth be told, based on the facts that they have. So they might want to add somebody else a second chair to kind of give it another look, or a little different flavor. But I don't see any major changes in the prosecuting team on this case.
Any other takeaways that you think after we're kind of hearing today? This is the first, like we mentioned, the first of many before the next one coming up on August 14th. Any other takeaways that we haven't touched on yet?
I just think we're going to still see more from the defense. More. They're going to file more motions. There's going to be some more showboating. And I think they're going to milk this case, just sort of like they did the last time. I mean, they're going to continue to give press conferences and talk about the case and file motions that they probably have little chance of winning. So the big question is going to be whether or not, when the case goes to trial, they employ any kind of different strategies.
And we'll see those. And we're going to see them right here as well on WLTX Plus, as well as WLTX.com. John, thank you so much for being here.
Thank you so much.
Yeah, we always appreciate you. And don't worry, we're going to be putting this full interview with John on our website, WLTX.com. But again, we will be back here August 14th. It's already on the calendar for the next pretrial. And we're going to have full analysis, and we're going to be showing you live inside that courtroom as it comes in on that Friday, August 14th. Again, thank you all so much for joining us right here for After Hours as we continue to follow this new retrial.